Okay, we are on record for purposes of a preliminary hearing. The court authorized a petition yesterday that requested removal of this child, and the child was removed. And we've had an opportunity for Mr. McFarland to talk to the parents from whom the child was removed, but we'll go from there after appearances.
Lee Heiss, lawyer, guardian ad litem.
Ms. Stasia Thomas, counsel for the department. Ms. Kelly.
Brittany Kelly for the department.
Michael McFarland, representing mother, and her last name actually has a capital I, MC capital I, and TYRE. Thank you.
Thank you.
Ma'am, could you please introduce yourself?
Kathleen McIntyre.
Thank you.
All right, Mr. Roberts, would you like to identify yourself?
Dean Roberts.
And you are the father of the child, is that right?
Yes.
And you have the child in your possession at this time?
Yes.
Thank you. All right, thank you. Ms. McIntyre, do you have a copy of the petition?
Yep.
All right. Mr.
We waive its
McFarland.
reading, Your Honor. I've gone over the rights with her. We are asking for a non-jury offense trial. Like I said, she does not require you rereading this back.
Very good. You inquired about Native American heritage?
I do, Your Honor. She indicates none.
All right, and I do see that there is another case that seems to concern the minor child on custody and parenting time. Do you know if that is the only case?
As far as concerning the child, my client advises me that there is also an active warrant for her in St. Clair County. St. Clair, Your Honor.
Thank you. I appreciate that information. All right. Ms. McIntyre, you have the right to a trial by judge or jury, wherein the petitioner would have to prove that there's been a preponderance of the evidence that one or more of the allegations in the complaint or the petition are true, and that they constitute a violation of the statute, that of course poses a risk of harm to the child. And I know that Mr. McFarland has had a chance to talk with you about that as well. You have the right to an attorney, which is why he's here. He'll be here with you for all subsequent hearings as well, in case you need him. You have the right to admit or deny at this point. Also the right to seek placement of your child for all intents and purposes as part of today's hearing. Have you had a chance to talk to Mr. McFarland to your satisfaction on those issues?
Yes.
Very good. Mr. McFarland, how would you like to proceed today?
As far as placement, Your Honor, she's satisfied with the child being with father. She has no family down here, no non-relative potential placement. So she's okay with the child placed with father. I just have a brief opening regarding risk, Your Honor, or lack thereof.
Go ahead.
Your Honor, my client's in jail. There is a bond hearing. My understanding is this Friday, although there is another warrant for her in St. Clair County, which she'll most likely will be picked up and transported. So I'm not sure that there is a risk of harm at this point, whether being incarcerated and possibly still being incarcerated, to authorize this petition. That would be my concern.
All right. Ms. Thomas, would you care to take any testimony or rebut that? I know I've looked at your petition and I have authorized it already. But if you'd like to make a bit of a record on that today, here's your opportunity.
Yes, Your Honor. This court must look at the petition at the time it was filed and what was true at that point in time. And at the time it was filed, Ms. McIntyre was in fact in the community with a child, and the allegations contained in the petition can be testified to by Ms. Kelly. We do understand that she is incarcerated. That might take some time, but there is always the potential that she could make a bail bond and or any other bond. And for those reasons, we would request that the case continue, in part also to allow mom to benefit from services and from having and her right to have counsel. If we take that away, those rights also go away. So for those reasons, I believe we are ripe to continue forward.
All right. Would you like to take any testimony today?
Yes, Your Honor. I will ask Ms. Kelly to be sworn in to provide testimony on the probable cause. Ms. Kelly, how are you involved in this matter?
I was the initial on-call CPS worker the weekend the complaint came in, and then I was assigned to it Monday morning.
And as the worker on this matter, or the investigator, how did you draft this petition that is in front of the court?
I did.
And to the best of your knowledge, do you believe that the allegations contained in the petition are still factually accurate?
Yes, I do.
And can you explain for the record what processes you used during your investigation to obtain the information that is included in the petition?
I spoke with a lot of collateral contacts, friends and family. I engaged a lot with law enforcement regarding criminal activity warrants that were active. I went to the home. I was at the home the first day for about an hour, trying to engage, knocking on the door. I called Kathleen and tried to engage with her over the phone. I texted her. Her sister came over and tried to help also engage, which we were able to speak through a window at the home. And then she had asked us to leave the home, so we left. That following Sunday, I dropped off bags of groceries to the home. I took a picture. I texted them to Kathleen and let her know that the groceries were out there. I asked her to go get them. That following Monday, I drove back by the house. The groceries were gone. I attempted home visits, text messages throughout the week. I asked her if there were any services that we could provide to her, if I could help her get into treatment, if she needed any more groceries. I did not have any contact back from her after, I believe, Wednesday of last week. The family and friends I had spoken to said they had no contact with her last week either. And that is when we had a removal meeting with the department and decided that this was the way to proceed. And as it relates to Mr. Roberts, were you able to speak with him at all during this process? We spoke via phone quite a bit. I had advised him that he has the right to file an ex parte order as a parent, which he did end up filing last Tuesday through St. Clair County. That's where the friend of court order is out of. And then I received a call Friday afternoon around 3:30 from Judge Tomlinson, who's out of St. Clair County, from his secretary stating that they would not be granting the ex parte order and advised that CPS file their own removal order.
And what do you believe is the substantial risk of harm to the child's life, physical health, or mental well-being if he were to remain in the care and custody of Ms. McIntyre at this time?
The allegations we received specifically stated that Kathleen was intoxicated and slurring her words. There is a long previous history of substance use of alcohol by Kathleen. She has done a lot of substance use services in the past. And when we entered the home last night, there were empty, I believe they were Twisted Tea cans. And I believe she was intoxicated. She would not scream for us. I asked law enforcement if they would be completing a breathalyzer or any kind of blood draw on her. They said they weren't really sure at that time. But I believe that the risk of harm would be the neglect. He is 3 years old. We were unsure if he was being fed, if he was being bathed. He is still in diapers, which the diaper was full when we removed him last night. Her substance use is affecting her parenting. And also her substance use has impacted criminality also, as she has charges. Her most recent one was operating under the influence from December of 2023.
As it relates to the reasonable efforts to prevent removal, in addition to the efforts put forth during your investigation with the weekend and then the following week, has CPS had any involvement with this family in the past year or two?
Yes, there was an open case. I believe it was from June 2023 until September 2023. That case was opened due to a domestic violence incident between Kathleen and her mother. We had opened a case with Kathleen as the perpetrator. There was alcohol involved during that incident. We offered services. Most of the kids were with their dads at that point. Kathleen was doing really good. She was on probation. Probation had no concerns at that time. She was screening for them multiple times a week for alcohol and drugs. I believe all of her screens were clean. Probation, when I spoke with probation last week regarding Kathleen, they said she was doing really, really well. And then all of a sudden stopped reporting. So when we had the case last year, she was doing really well. Services were very engaged, and she seemed to be making progress with them up until we received the new complaint.
And for placement at this time, there's no reason to disrupt the release of the child to the legal father at this time. Is that correct?
Correct.
And at this time, are you continuing to ask the court to authorize this petition?
Yes.
If mother is released from jail, what would be, in this, I don't know if this is something you can answer, but what would be the recommendation for parenting time?
I don't think I can answer that right now. I think there's a lot of factors. Kathleen has been extremely uncooperative with us. And I think I'd like to see services put in place and actively engaged with Kathleen before any visits were offered.
You mentioned other children earlier in your testimony. Does Ms. McIntyre have other children?
She does.
And they are not part of this petition, is that correct?
Correct.
How many other children does she have?
3.
And where are those children?
Her oldest child is placed in a guardianship with maternal grandmother. I believe that was put into place about 11 years ago. And then the other 2 children are with their fathers.
And do you know if the other 2 have parenting time with Ms. McIntyre?
I have not been able to get in contact with one of the child's dads. I did, on our initial complaint, her daughter Avery was listed as a victim. I had called her father and verified with him that she had not seen Kathleen in a couple months. So she had not had parenting time with that child in quite a while.
Is there anything else that you would like to report to the court for the court to make its decision today?
I did try to engage with Kathleen during the removal last night. She asked me not to speak to her. I did go back. I went to the Lenawee County Jail today around 1 p.m. before court. And I also tried to engage with her there to talk about services or if there was anything we could do. And she, after about 10 minutes, she asked me to leave. So I think I tried to engage with her. I think it's a matter of her deciding that she needs to engage with us to receive services.
Thank you. Your Honor, I have no further questions for this witness.
Cross-exam?
I do. This is your signature on the petition that's been submitted to the court, correct?
Correct.
That means everything in here you believe to be true. Is that correct?
Correct.
It says on January 20th, Kathleen is under the influence of alcohol. Did you see her on that date under the influence of alcohol?
No, but number 6 says that those were the 2 sets of allegations that came in. So the sets of allegations that come in aren't necessarily believed to be true until we can prove otherwise, obviously.
So you're able to prove otherwise that on January 20th, she was under the influence of alcohol?
No, but those were the allegations from the original complaint, which is why I listed them in the petition.
So you don't know whether that's true or not, correct, what you stated?
I know that the allegation that was made was true it was on my complaint. So
I understand the allegation, but you don't know whether the underlying
No, I've not been able to.
factual, only one of us can speak at a time, okay? It's hard for the court reporter. So my question is, you don't know if that is true, that on the 20th of this year, of January this year that she was under the influence. You do not personally know that, correct?
Correct.
You do not personally know that she was under the influence of drugs also, correct?
I've been unable to have a conversation with her as to what the allegations really entailed, so no, I can't.
And you didn't hear that she was doing so, did you?
Correct.
You did not see her drunk driving, correct?
I have a video of her with a beer can in her hand while she was driving. I don't have a time and date stamp on it, but I do have.
Was she swerving?
She had a beer can in her hand while she was driving, so it was a 7-second video maybe.
What kind of beer?
Maybe a Michelob Ultra. I've
Do you
watched
know?
the video 3 times.
Do you know for sure?
No,
You know that wasn't a Mountain Dew.
I guess it could have been a Mountain Dew.
So you saw her with a drink, and that's about all you could say, correct? A beverage.
A beverage, correct.
Okay. You also stated you had some concern that with her warrants, she might be arrested and the child would be without somebody, correct?
I knew she had warrants and that if the police had verified she was home, she would be arrested.
No, the police were there on multiple occasions for a welfare check and they didn't, with their warrants, get inside to arrest her, did they?
Kathleen did not answer the door now.
You heard my client state there was no confidentiality when she told me that she might yet be arrested on an outstanding warrant in St. Clair County, correct?
Correct, I was already aware of that too.
Okay. This would give father actually time to perhaps file a petition for exclusive custody, correct?
He filed an ex parte order and they did set a hearing for, I believe it was February 5th.
Thank you. You jumped ahead and answered what I was going to ask you. So there's a possibility that he could have exclusive custody of this child on February 5th, and then the child, there's no reasonable risk of harm if that happens, correct?
I would like to say that, but there was a custody order motion filed last year when we had an open case and the court did not grant him custody, which is how he ended up back in Kathleen's care.
Okay. But I'm saying if he is granted custody, your belief is then there is no risk of harm, correct?
If he has full custody and is not allowing parenting time, correct.
As far as parenting time for mother, what about if she screens for alcohol and drugs prior to a visit and it's supervised? Would that be acceptable?
If she's not incarcerated and working with services, I would agree to that.
Why does she have to work with services if she is negative for any controlled substances?
I believe she has severe mental health that's possibly untreated right now. The substance use has been an ongoing concern for a very long time.
Can you tell me just what paragraph says severe mental health?
In the allegations, it talks about that she is self-harming and that she was suicidal.
Once again, you did not see her self-harming, correct?
I did observe cuts on her arm. And I took a picture of those during the removal.
Did she admit to you she was self-harming?
She would not communicate with me,
She's never made any ideations in your presence, correct?
not in front of me.
Who are the reporting people who are telling you these things?
That is
Objection, Your
confidential.
Honor, that is, objection, Your Honor, that is privileged and confidential under statute.
Yeah, she, that was her response as well, so I think it's moot, she's handled it, I'm not gonna make her answer that question.
Perfectly fine. I have no further questions, Your Honor.
You say that you'd worked with this family before, or you just read things about the ongoing from last time?
The CPS has worked with them, not me personally. But I spoke with the ongoing worker and the previous investigator from the 2023 investigation.
Is there a history of issues with mental health in the prior case?
I don't know if that was reported to me by a worker specifically. A family member did report mental health that was possibly unmedicated.
Ms. Heiss, do you have any questions for this witness?
only one. Do you know what the current bonds are set at for this mother?
No, I don't have a specific number, no.
Okay,
And when
nothing
I
further.
spoke to, oh, I'm sorry.
All right, any further redirect or questions or witnesses, Ms. Nastasia Thomas?
No, Your Honor, thank you.
All right, thank you for your testimony. May I return to your seat? Anyone you'd like us to hear from, Mr. McFarland?
If I could have my client, I'd like to limit my client's testimony to her possible outstanding warrants and how long she's going to be incarcerated. If that's going to open her up to everything else, then I won't. I don't know what the thoughts of the other participants are on that, Your Honor.
Well, she does have the right to admit or deny the allegations in the petition if you wish to address any of those, but then also to address placement. And I think those questions are relevant for that purpose.
Well, Your Honor, I've already mentioned placement and with the denying the allegations, she is denying those and that we're asking for a bench trial on those.
Okay.
So I thought it might be helpful to the court to know how long she's going to be incarcerated.
Very good, go ahead.
Thank you. Has she been sworn in, Your Honor?
She is.
Thank you. Ma'am, can you tell us exactly what you're in jail for?
Violation of probation. I am out of St. Clair County. I'm supervised in Lenawee County, so I see Jennifer Walsh. I caught an OWI, so therefore that was a violation of probation. So there's 2 warrants for which I'm here now, and then I'll respectively probably be transferred. If not transferred, when I bond out, go turn myself into St. Clair County.
And what is your bond currently set at?
5,000 cash as surety. But I have another.
Go ahead.
I have another bond hearing Friday, so I'm not gonna get a bail bondsman, pay it just so that they can transfer me. I'm just gonna sit in jail and go through it that way.
I want you to know that even though you're entitled to a trial, we've requested, and your request is that you wish to have a bench trial, correct? A trial by the judge.
Yeah.
And they may offer you some services ahead of time. You don't have to do that, but that's something that you can do if offered to you, just so you understand, okay?
I'm open to any and all services, but
Okay.
the way that I was approached, it was approached with me, I had no understanding of why anything was going on. I was in more defense about it. I am currently on medication. I do therapy. So I don't think my mental health should be called into question. I have old scars on my arm.
And I questioned you about placement of your child. I'm just gonna use the say child, because this may be on Zoom. I don't want the name out there or on YouTube. The child, you're okay with the child being with Father Mr. Roberts. Is that my understanding?
Yeah, I am. I'm fine with that, but I do think that him and his girlfriend need to participate in services too, because there's been a number of times where they've tried to get me to come pick him up early because of the arguing and her having to call the police on him and him getting kicked out. Things like that. So if that's going to happen, then yes, I think that he needs to be involved in services too.
Okay. So you'd be free to, you would share that with the worker if she were to ask you any concerns you have about placement?
Absolutely. He has 3 warrants right now too, and I have told her that.
So what's Father's warrants for?
He has 2 out of Kalamazoo, I believe, and then he has 1 out of Macomb County.
And I see him shaking his head no, so I may just call him under oath to testify on that. Okay. That concludes what I want to ask you, because the rest we can cover at our trial. Well, lastly, you have no native blood, American Indian blood in your family as far as you know, correct?
No, I don't. I'm fine with co-residing with his father. That's perfectly fine. I just want Dean to, there's been fighting with him and Katie, and our relationship is not that great. So, I mean,
Okay.
I just want to make sure that if he's there, it's going to be fine.
Okay. I won't call him as a witness then. Nothing further, Your Honor.
Any questions, Ms. Thomas?
No, Your Honor.
Ms. Heiss?
No questions. Thank you.
All right. Any other witnesses?
No, thank you, Your Honor.
Anyone you'd like us to hear from, Ms. Heiss?
No witnesses today. Thank you.
All right, then comments, Ms. Thomas?
Your Honor, at this time, the department asked the court to consider the petition, the testimony of Ms. Kelly and Ms. McIntyre, and grant the request or the relief requested within the petition. Thank you.
How much time would you prefer that we set the trial out for, and how much time do you think you'll need for the trial?
Me?
Your
No,
Honor,
I'm sorry, that question was from Ms. Thomas.
given that this child will be with a non-respondent parent, I know that kind of gives us a little more room on our timelines. I would request a trial date in mid to late March if available, to allow us to sort of see what happens at that custody hearing, see what happens in the criminal cases, and maybe we'll have a resolution before coming back.
We are requesting sooner rather than later, Your Honor. You know, it's one reason our discussion was a bench, not a jury trial.
Very good.
And then I do reserve closing remarks also.
All right. Would you like to go?
If I may, Your Honor. As the attorney for the agency said, this petition is based upon the time this was filed, not the current status. And as I called the worker to the stand, she has no personal knowledge about alcoholism, no personal knowledge about drugs, no personal knowledge about whether my client was driving drunk. She has no personal knowledge that my client still has ongoing mental health, that she saw scars, but nothing that would indicate, no testimony that there was current issues there, Your Honor. So a whole lot of this person reported to me, this person reported to me, I'm speculating this, but nothing at the time this was filed from the worker, Your Honor. There's no testimony here today other than her hearsay, as I realize that can be admitted, but not during the trial. But can't be. But there's really nothing of substance here other than somebody said, we can't tell you who said this. I didn't personally see it, so it has to be true. I don't think that's enough. There is a hearing scheduled for February 5th, I think is the date stated by the worker. The father has on his motion for custody. I don't think that we can have a trial before that date, quite frankly. So this issue may just be resolved with no risk of harm. If he does get custody, I'm not advocating for that. I'm just stating that as an issue. So trial date after that period of time, and I would say that the burden's not been met. That's our position on this, Your Honor. And there's no harm to the child because my client's incarcerated. There's yet another warrant for her arrest. She's not making bond right now. Father has the child, so that's where we're arrested.
All right, Ms. Heiss?
Thank you, Your Honor. I join the state's position in this case, and I recommend that you find it in the best interest of the child to grant the relief requested.
Thank you. Well, I can offer you a bench trial date as early as the morning of March 5th at 9.
Either date work.
Your hall trial is not going at 10, Your Honor?
On
the 25th?
That's no longer a trial.
Okay. So I'm available on the 25th and the 26th.
Let's schedule this for the afternoon of March 25th then for purposes of bench trial. Witnesses, exhibits, if any, should be filed and exchanged by March 5th at the pretrial. So for scheduling purposes, that is the path forward. I will be looking for at the pretrial, Ms. Kelly, I'd like a copy of the custody order and a copy of any order that comes out as a result of that February 5th case. This court is required to file a notice of prior proceedings. So the St. Clair Court will be on notice that we have a petition and that has resulted in a removal order for the moment. On the issue of visitation, I can appreciate your concerns, but I think that we would need the weigh-in of a professional counselor to let us know whether or not it is a risk of harm for mothers to have parenting time with the child. For now, we'll just issue the requirement to have professional supervised parenting time on a weekly basis, pending recommendations from a counselor. If you could implement that, I know that will be a referral that you can make right away. The court has taken jurisdiction over the child at this point, and that will remain in place pending further proceedings. I do find that the substantial risk of harm associated with allowing the child to return to the care of mother continues to exist, and that placement with father at this point is the safest and least restrictive under the circumstances, and will await further developments in the St. Clair Circuit Court case to determine whether or not our interventions continue to be necessary. But it would appear that at least preliminarily, there's been a showing that Ms. McIntyre can certainly use some services and has some things to overcome, at least with regard to her pending warrants that take her away from being able to provide proper care and custody from the child at this time. Some of those findings were made yesterday, and they continue to be true today for the obviously new developments that we've seen today, which find us seeing Ms. McIntyre from Lenawee County Jail and potentially tackling some other warrants in criminal matters. The placement with father does give us some flexibility on the time frame of these proceedings. So if there is, for some reason, the need to adjourn the dates out, the court is happy to do that. Mr. Roberts, could you confirm whether or not you believe there's any Native American history or heritage on your side that this child would have links to any Native American tribe or band?
No, I don't think so.
Okay, very good. All right, well, that'll be it then for today.
One parenting time question, Your Honor, if I might. My client is bonded out to St. Clair County. I know some jurisdictions do allow visits for parents in jail. Is that something that could be considered if it's available to her up there with the counselor weighing in?
The order for once a week professionally supervised parenting time will remain in full force and effect until we come back for the pretrial. So if those arrangements can be made with the jail, I would certainly welcome that question. So Ms. Kelly, I think be prepared to answer that question at our next juncture, which will, I'm sure, mean you'll have to keep track of what happens with Ms. McIntyre and what opportunities would be available to her from each jail. But that's pretty typical for the incarcerated parent protocol. Is there anything else that you need from me this afternoon, ladies and gentlemen?
No, thank you.
Nope,
Your
I'm all
Honor,
set.
the department would ask the court to order Ms. McIntyre to comply with a drug test, and Ms. Kelly can request that the swab include testing for alcohol as well.
Your Honor, she's in jail. I'm not sure what the purpose of that is, so.
I am not sure on that one at the moment, Ms. Thomas. I would need probably some authority, since she's not an adjudicated parent at this point, to support that request at this juncture. But I obviously would remain available to you if you wanted to find that and write that up and give it to us for review. I appreciate your concern and the concern of the department, but at this juncture, with it being essentially pre-trial status, I don't have jurisdiction yet. I need to see what authority is out there for me to issue that order.
Okay, Your Honor, thank you.
Any other questions?
No, thank you.